Chapter 8 of Commerce. Paragraph 83. Of Home and Foreign Trade. It is commerce that enables individuals and whole nations to procure those commodities which they stand in need of, but cannot find at home. Commerce is divided into home and foreign trade. The former is that carried on in the state between the several inhabitants. The latter is carried on with foreign nations. Paragraph 84. Utility of the home trade. The home trade of a nation is of great use. It furnishes all the citizens with the means of procuring whatever they want, as either necessary, useful, or agreeable. It causes a circulation of money, excites industry, animates labor, and, by affording subsistence to a great number of people, contributes to increase the population and power of the state. Paragraph 85. Utility of foreign trade. The same reasons show the use of foreign trade, which is moreover attended with these two advantages. M-1. By trading with foreigners, a nation procures such things as neither nature nor art can furnish in the country it occupies. And secondly, if its foreign trade be properly directed, it increases the riches of the nation, and may become the source of wealth and plenty. Of this the example of the Carthaginians among the ancients, and that of the English and Dutch among the moderns, afford remarkable proofs. Carthage, by her riches, counterbalanced the fortune, courage, and greatness of Rome. Holland has amassed immense sums in her marshes. A company of her merchants possesses whole kingdoms in the east, and the governor of Batavia exercises command over the monarchs of India. To what a degree of power and glory has England arrived! Formerly her warlike princes and inhabitants made glorious conquests, which they afterwards lost by those reverses of fortune so frequent in war. At present, it is chiefly commerce that places in her hand the balance of Europe. Paragraph 86. Obligation to cultivate the home trade. Nations are obliged to cultivate the home trade, M-first, because it is clearly demonstrated from the law of nature that mankind ought mutually to assist each other, and, as far as in their power, contribute to the perfection and happiness of their fellow creatures, whence arises, after the introduction of private property, the obligation to resign to others, at a fair price, those things which they have occasion for, and which we do not destine for our own use. Secondly, society being established with the view that each may procure whatever things are necessary to his own perfection and happiness, and a home trade being the means of obtaining them, the obligations to carry on and improve this trade are derived from the very compact on which the society was formed. Finally, being advantageous to the nation, it is a duty the people owe to themselves, to make this commerce flourish. Paragraph 87. Obligation to carry on foreign trade. For the same reason, drawn from the welfare of the state, and also to procure for the citizens everything they want, a nation is obliged to promote and carry on a foreign trade. Of all the modern states, England is most distinguished in this respect. The Parliament have their eyes constantly fixed on this important object. They effectually protect the navigation of the merchants, and, by considerable bounties, favour the exportation of superfluous commodities and merchandises. In a very sensible product, may be seen the valuable advantages that kingdom has derived from such judicious regulations. Paragraph 88. Foundation of the laws of commerce, M-right of purchasing. Let us now see what are the laws of nature and the rights of nations in respect to the commerce they carry on with each other. Men are obliged mutually to assist each other as much as possible, and to contribute to the perfection and happiness of their fellow creatures. Prelim. Paragraph 10. Whence it follows, as we have said above, paragraph 86, that, after the introduction of private property, it became a duty to sell to each other, at a fair price, what the possessor himself has no occasion for, and what is necessary to others. Because, since that introduction of private property, no one can, by any other means, procure the different things that may be necessary or useful to him, and calculated to render life pleasant and agreeable. Now, since right springs from obligation, prelim. Paragraph 3. The obligation which we have just established gives every man the right of procuring the things he wants, by purchasing them at a reasonable price from those who have themselves no occasion for them. We have also seen, prelim. Paragraph 5, that men could not free themselves from the authority of the laws of nature by uniting in civil society, and that the whole nation remains equally subject to those laws in its national capacity, so that the natural and necessary law of nations is no other than the law of nature properly applied to nations or sovereign states. Prelim. Paragraph 6, from all which it follows, that a nation has a right to procure, at an equitable price, whatever articles it wants, by purchasing them of other nations who have no occasion for them. This is the foundation of the right of commerce between different nations, and, in particular, of the right of buying. Paragraph 89. Right of selling. We cannot apply the same reasoning to the right of selling such things as we want to part with. Every man and every nation being perfectly at liberty to buy a thing that is to be sold, or not to buy it, and to buy it of one rather than of another, the law of nature gives to no person whatsoever any kind of right to sell what belongs to him to another who does not wish to buy it. Neither has any nation the right of selling her commodities or merchandise to a people who are unwilling to have them. Paragraph 90. Prohibition of foreign merchandise. Every state has consequently a right to prohibit the entrance of foreign merchandises, and the nations that are affected by such prohibition have no right to complain of it, as if they had been refused an office of humanity. Their complaints would be ridiculous, since their only ground of complaint would be that a profit is refused to them by that nation who does not choose they should make it at her expense. It is, however, true, that if a nation was very certain that the prohibition of her merchandises was not founded on any reason drawn from the welfare of the state that prohibited them, sight would have cause to consider this conduct as a mark of ill will shown in this instance, and to complain of it on that fooling. But it would be very difficult for the excluded nation to judge with certainty that the state had no solid or apparent reason for making such a prohibition. Paragraph 91. Nature of the right of buying. By the manner in which we have shown a nation's right to buy of another what it wants, it is easy to see that this right is not one of those called perfect, and that are accompanied with a right to use constraint. Let us now distinctly explain the nature of a right which may give room for disputes of a very serious nature. You have the right to buy of others such things as you want, and of which they themselves have no need. You make application to me, I am not obliged to sell them to you, if I myself have any occasion for them. In virtue of the natural liberty which belongs to all men, it is I who am to judge whether I have occasion for them myself, or can conveniently sell them to you, and you have no right to determine whether I judge well or ill, because you have no authority over me. If I, improperly, and without any good reason, refuse to sell you at a fair price what you want, I offend against my duty. You may complain of this, but you must submit to it, and you cannot attempt to force me, without violating my natural right, and doing me an injury. The right of buying the things we want is then only an imperfect right, like that of a poor man to receive alms of the rich man. If the latter refuses to bestow it, the poor man may justly complain, but he has no right to take it by force. If it be asked, what a nation has a right to do in case of extreme necessity, this question will be answered in its proper place in the following book, chapter 9. Paragraph 92. Every nation is to choose how far it will engage in commerce. Since then a nation cannot have a natural right to sell her merchandises to another that is unwilling to purchase them, since she has only an imperfect right to buy what she wants of others, since it belongs only to these last to judge whether it be proper for them to sell or not. And finally, since commerce consists in mutually buying and selling all sorts of commodities, it is evident that it depends on the will of any nation to carry on commerce with another, or to let it alone. If she be willing to allow this to one, it depends on the nation to permit it under such conditions as she shall think proper. For in permitting another nation to trade with her, she grants that other a right, and everyone is at liberty to affix what conditions he pleases to a right which he grants of his own accord. Paragraph 93. How a nation acquires a perfect right to a foreign trade. Men and sovereign states may, by their promises, enter into a perfect obligation with respect to each other, in things where nature has imposed only an imperfect obligation. A nation, not having naturally a perfect right to carry on a commerce with another, may procure it by an agreement or treaty. This right is then acquired only by treaties, and relates to that branch of the law of nations termed conventional prelim. Paragraph 24. The treaty that gives the right of commerce is the measure and rule of that right. Paragraph 94. Of the simple permission of commerce. A simple permission to carry on commerce with a nation gives no perfect right to that commerce. For if I merely and simply permit you to do anything, I do not give you any right to do it afterwards in spite of me. You may make use of my condescension as long as it lasts, but nothing prevents me from changing my will. As then every nation has a right to choose whether she will or will not trade with another, and on what conditions she is willing to do it. Paragraph 92. If one nation has for a time permitted another to come and trade in the country, she is at liberty, whenever she thinks proper, to prohibit that commerce to restrain it to subject it to certain regulations, and the people who before carried it on cannot complain of injustice. Let us only observe that nations, as well as individuals, are obliged to trade together for the common benefit of the human race, because mankind stand in need of each other's assistance. Prelim. Paragraph 10, 11, and Book I. Paragraph 88. Still, however, each nation remains at liberty to consider, in particular cases, whether it be convenient for her to encourage or permit commerce. And as our duty to ourselves is paramount to our duty to others, if one nation finds herself in such circumstances that she thinks foreign commerce dangerous to the state, she may renounce and prohibit it. This the Chinese have done for a long time together. But, again, it is only for very serious and important reasons that her duty to herself should dictate such a reserve. Otherwise, she could not refuse to comply with the general duties of humanity. Paragraph 95. Whether the laws relating to commerce are subject to prescription. 39. We have seen what are the rights that nations derive from nature with regard to commerce, and how they may acquire others by treaties. Let us now examine whether they can found any on long custom. To determine this question in a solid manner, it is necessary first to observe that there are rights which consist in a simple power. They are called in Latin, jura mere facultates, rights of mere ability. They are such in their own nature that he who possesses them may use them or not, as he thinks proper, being absolutely free from all restraint in this respect, so that the actions that relate to the exercise of these rights are acts of mere free will, that may be done or not done, according to pleasure. It is manifest that rights of this kind cannot be lost by prescription, on account of their not being used, since prescription is only founded on consent legitimately presumed, and that, if I possess a right which is of such a nature that I may or may not use it, as I think proper, without any person having a right to prescribe to me on the subject, it cannot be presumed, from my having long forborne to use it, that I therefore intend to abandon it. This right is then imprescriptible, unless I have been forbidden or hindered from making use of it, and have obeyed with sufficient marks of consent. Let us suppose, for instance, that I am entirely at liberty to grind my corn at any mill I please, and that during a very considerable time, a century if you please, I have made use of the same mill, as I have done in this respect what I thought proper. It is not to be presumed, from this long-continued use of the same mill, that I meant to deprive myself of the right of grinding at any other, and, consequently, my right cannot be lost by prescription. But now suppose that, on my resolving to make use of another mill, the owner of the former opposes it, and announces to me a prohibition. If I obey his prohibition without necessity, and without opposition, though I have it in my power to defend myself, and know my right, this right is lost, because my conduct affords grounds for a legitimate presumption that I chose to abandon it. Let us apply these principles. Since it depends on the will of each nation to carry on commerce with another, or not to carry it on, and to regulate the manner in which it chooses to carry it on. Paragraph 92. The right of commerce is evidently a right of mere ability, jus mere facultates, a simple power, and consequently is imprescriptible. Thus, although two nations have treated together, without interruption, during a century, this long usage does not give any right to either of them. Nor is the one obliged on this account to suffer the other to come and sell its merchandises, or to buy others. They both preserve the double right of prohibiting the entrance of foreign merchandise, and of selling their own wherever people are willing to buy them. Although the English have from time immemorial been accustomed to get wine from Portugal, they are not on that account obliged to continue the trade, and have not lost the liberty of purchasing their wines elsewhere. 40. Although they have, in the same manner, been long accustomed to sell their cloth in that kingdom, they have, nevertheless, a right to transfer that trade to any other country, and the Portuguese, on their part, are not obliged by this long custom, either to sell their wines to the English, or to purchase their cloths. If a nation desires any right of commerce which shall no longer depend on the will of another, she must acquire it by treaty. Paragraph 96. Imprescriptibility of rights founded on treaty. What has been just said may be applied to the rights of commerce acquired by treaties. If a nation has by this method procured the liberty of selling certain merchandises to another, she does not lose her right, though a great number of years are suffered to elapse without its being used, because this right is a simple power, jus mere facultates, which she is at liberty to use or not, whenever she pleases. Certain circumstances, however, may render a different decision necessary, because they imply a change in the nature of the right in question. For instance, if it appears evident that the nation granting this right granted it only with the view of procuring a species of merchandise of which she stands in need, and if the nation which obtained the right of selling neglects to furnish those merchandises, and another offers to bring them regularly, on condition of having an exclusive privilege, it appears certain that the privilege may be granted to the latter. Thus the nation that had the right of selling would lose it, because she had not fulfilled the tacit condition. Paragraph 97. Of monopolies and trading companies, with exclusive privileges. Commerce is a common benefit to a nation, and all her members have an equal right to it. Monopoly, therefore, in general, is contrary to the rights of the citizens. However, this rule has its exceptions, suggested even by the interest of the nation, and a wise government may, in certain cases, justly establish monopolies. They are commercial enterprises that cannot be carried on without an energy that requires considerable funds, which surpass the ability of individuals. There are others that would soon become ruinous, were they not conducted with great prudence, with one regular spirit, and according to well-supported maxims and rules. These branches of trade cannot be indiscriminately carried on by individuals. Companies are therefore formed, under the authority of government, and these companies cannot subsist without an exclusive privilege. It is therefore advantageous to the nation to grant them. Hence have arisen, in different countries, those powerful companies that carry on commerce with the East. When the subjects of the United Provinces established themselves in the Indies on the ruin of their enemies the Portuguese, individual merchants would not have dared to think of such an arduous enterprise, and the state itself, wholly taken up with the defense of its liberty against the Spaniards, had not the means of attempting it. It is also certain beyond all doubt, that, whenever any individual offers, on condition of obtaining an exclusive privilege, to establish a particular branch of commerce or manufacture which the nation has not the means of carrying on, the sovereign may grant him such privilege. But whenever any branch of commerce may be left open to the whole nation, without producing any inconvenience or being less advantageous to the state, a restriction of that commerce to a few privileged individuals is a violation of the rights of all the other citizens. And even when such a commerce requires considerable expenses to maintain forts, men of war, and sea, this being a national affair, the state may defray those expenses, and, as an encouragement to industry, leave the profits of the trade to the merchants. This is sometimes done in England. Paragraph 98. Balance of trade, and attention of government in this respect. The conductor of a nation ought to take particular care to encourage the commerce that is advantageous to his people, and to suppress or lay restraints upon that which is to their disadvantage. Gold and silver having become the common standard of the value of all the articles of commerce, the trade that brings into the state a greater quantity of these metals than it carries out, is an advantageous trade, and, on the contrary, that is a ruinous one, which causes more gold and silver to be sent abroad than it brings home. This is what is called the balance of trade. The ability of those who have the direction of it consists in making that balance turn in favor of the nation. Paragraph 99. Import duties. Of all the measures that a wise government may take with this view, we shall only touch here on import duties. When the conductors of a state, without absolutely forcing trade, are nevertheless desirous of diverting it into other channels, they lay such duties on the merchandises they would discourage as will prevent their consumption. Thus, French wines are charged with very high duties in England, while the duties on Portugal are very moderate, because England sells few of her productions to France, while she sells large quantities to Portugal. There is nothing in this conduct that is not very wise and extremely just, and France has no reason to complain of it. Every nation having an undoubted right to make what conditions she thinks proper, with respect to receiving foreign merchandises, and being even at liberty to refuse taking them at all.